Madam Clerk, please open court.
The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Thank you. The court calls 406A19 Chisum versus Campagna et al. It is our understanding that the parties will split the argument as follows. Is there something weird happening there? Does that sound strange?
I'm getting a little bit of a buzz from you.
Okay.
Is anybody else hearing that?
I'm getting a bit of an echo
Okay.
and a sort of buzzing sound.
Fred, do we know what that is?
I am not sure, Chief. Sometimes we get an echo from somebody else's microphone, but I'm not sure. We could try adjusting your volume down a little bit potentially.
Okay. Is that better? We understand that the parties will split the argument as follows. First, the defendant's appellants, then second, plaintiff cross plaintiff. I'm sorry, second is plaintiff cross appellant. Third is defendant's appellants. Fourth is plaintiff cross plaintiff. And fifth is defendant's appellants. And you all understand that you'll be taking measure to keep track of your time. Madam Clerk, I know that you will assist us as best you can, and I appreciate that. Mr. Shipman.
Madam Chief Justice, justices of the court, may it please the court. Having studied, briefed, and argued the law before the courts of this state, including honorably and humbly this court, on as many occasions as I've had the honor to do that, I've come to believe that after all of these years that I'm old school. For instance, old school and the notion that I'm not standing before this court to deliver this argument is foreign to me. Old school has included the notion that this court has long held that a party may not sleep on their rights, that they must be vigilant, that the advice and knowledge of a lawyer should be trusted unless there's some reason not to, that knowledge of an attorney is imputed to his or her own client. And old school for me has included since my first year in law school that the statute of limitations for any, quote, obligation or liability arising under a contract is 3 years from the date that any cause of action accrues, from the date that any promise is broken, from the date that any injury, however slight, occurs, with lack of knowledge not suspending or postponing the running of the statute of limitations. In adopting an actual knowledge of a breach before a statute of limitation begins to run, both the plaintiff and the business court wishes this court to move to new school, to abandon established precedent of this court, be it Jewell, Pierce, Christenberry, Pemby, and adopt a new school rule as to when a cause of action for breach of contract accrues. A rule that would reward lack of vigilance, that would create a mass of commercial uncertainty, a rule that ignores the notion that statutes of limitations operate inexorably, inflexibly, without regard to the merits of the underlying claim. Here, the relationship between the parties, the duties and responsibilities imposed upon the defendants as managers of these LLCs arise from express contracts in the form of the operating agreements. The overall transactions, the attendant rights of the parties, the obligations are clearly, therefore, contractual in nature. And any alleged failure to perform, therefore, the duties as managers of the LLC is tantamount to a breach of contract. The business court held that the plaintiff's rights under the operating agreement had been violated more than 3 years prior to the filing of any individual or derivative claim, but found that the only way that an action accrued for interest having been eliminated in these LLCs was if the plaintiff had actual notice of it, and then created what we contend to be a fiction by saying that the plaintiff was still a member, ignored the testimony and evidence about the advice and consent of the attorney for both Mr. Chisum individually and the LLCs, and retroactively afforded the plaintiff standing to bring a derivative claim, and determined as a matter of law that liability could be imposed for acts that occurred more than 3 years from the date that any action was filed. However, given when any injury occurred, given that there's no requirement that the plaintiff actually know when any injury occurred, given that the LLCs actually knew when any injury occurred, any cause of action relating to these contracts accrued more than 3 years prior to the filing of any action. Judge Tyson's dissent in Hull, which this court adopted per curiam, doesn't change those well-established principles. In fact, we take no issue with the outcome of the Hull case, because that case actually supports
Mr. Shipman, I've sat down and read a lot of these cases over the weekend, and it does seem to me that Hull is not the only decision by this court that makes reference to notice. Is that understanding right?
Justice Irvin, I believe that that is an accurate statement, and my response is the fact that notice is certainly a way that a statute of limitations for breach of contract can commence to run, but it is not the only way that a statute of limitations.
Hang on just a second, Mr. Shipman. This case is sufficiently complicated. If I don't stay with you, I may lose you for good. If it's a way but not the only way, then why is it the only way? Why is breach, regardless of notice, the only way in this case?
Well, because here we have injury. We have the acts of assumption of control. We have acts of the transfer of assets, which the plaintiff acknowledges, which the business court acknowledged, formed the basis of their claims for breach of fiduciary duty and constructive fraud. Those acts were done with the knowledge and consent of the LLC. So to the extent that any notice is required, the LLCs were on notice of all of these actions more than 3 years prior to the date that any of these actions took place. They were done with the knowledge and consent of the LLC's lawyers, indeed, the LLC lawyer's advice. So that is the reason why notice to the plaintiff individually to commence the statute of limitations as to any derivative claim is not required. The managers did not owe fiduciary obligations to the plaintiff individually. They owed obligations to the company. That's why it was important that a jury fully understand as a matter of law what the role should be with respect to an LLC's lawyers, and whether or not the defendants could rely upon the independent advice provided by this lawyer as to the propriety of all the transactions. So again,
I may be jumping ahead of myself here a little bit, but you made throughout the briefs in this case, or your clients have a number of references to the actions of the attorneys in the account. Are you contending that the attorney-accountant issue is an absolute bar to the claims that the plaintiff has asserted, or are you contending that work has a burden-shifting function?
Your Honor, our contentions on that are two. First, that knowledge of the attorney for the LLCs is imputed to the LLC. Next, with respect to the failure to give the fair, open, and honest instruction, given that the evidence was undisputed, the trial court found that the defendants relied upon that advice to the extent that a jury was permitted to get to breach of fiduciary duty or constructive fraud. The jury should have been instructed on fair, open, and honest. The first
and that's I think gets to my question. Is it your contention that the jury should have been instructed that if it found that there was a fair, open, and honest reliance upon the accountant and attorney, that is a bar to recovery, or that it is a shift of the burden?
It is not. It shifts the burden to the plaintiff.
Where is there any instruction that your client requested as shown in the record that reflects this burden shifting function?
Your Honor, it was certainly argued before the trial court in requesting the fair, open, and honest instruction that in giving that instruction, if the jury found that the defendants did act in a fair, open, and honest manner, it would shift the burden back to the plaintiff to show and prove actual fraud.
Is that language anywhere in a written instruction request?
Yes, I believe, Your Honor, in the record, indeed there is. I will, during counsel for the plaintiff's argument, I'll get a record citation for you in that respect. But
thank you.
Yes, it's certainly our understanding that that is indeed the case.
If I could go back to the statute of limitations argument, and I think I have a more fundamental question. You haven't brought a breach of contract claim. And as I understand the arguments, you're saying that the statute of limitation issue turns on breach of contract because that's what gives the plaintiff the standing as a member of the LLC to bring a derivative action. And what I'm struggling with is what case establishes that the statute of limitations for a declaratory judgment action depends on the statute of limitations for the underlying action?
Your Honor, we have cited cases in our brief that given that the underlying nature of a declaratory judgment action depends upon the nature of the relief that you are seeking or the nature of the controversy arising here by contract, that was the plaintiff's declaratory judgment. They wanted a declaration that under the contract that his interest had not been properly eliminated.
Right, but the declaratory, there is no case that says, so declaratory judgment actions are not listed in the statute as having a particular statute of limitations.
No, ma'am, but you must have a case or controversy in order for there to be a declaratory judgment. And given that any statute of limitations expired on the underlying declaratory judgment request that rights under a contract be construed, then there was no case or controversy about that anymore. You can't bring in the other claims dependent upon the existence of a statute of limitations. Even the trial court acknowledged eventually that there was a statute of limitations for a declaratory judgment action. It was 1-52(1), but it was dependent upon when the plaintiff had notice of the breach. So
I'm still struggling with, there are numerous circumstances in which you can bring a declaratory judgment action, and it depends on whether or not there's a controversy between the parties, but it doesn't necessarily depend on you also having some other underlying claim.
I would agree that the declaratory judgment action says if there is a genuine case or controversy without regard whether further relief could be granted. I agree with that. But here, they went one step further. They determined that more than 3 years ago, there had been a breach of the plaintiff's individual rights, and then provided the plaintiff standing to bring derivative claims that were not brought within 3 years of the date that those acts took place. So it was a bootstrapping effect of a declaratory judgment action that has to be brought, we contend, for any underlying relief to be granted on the contract claim. It's got to be brought within 3 years of the date that any injury occurred, because otherwise, as Justice Newby recognized in the Christenberry case, we make stale claims not stale. We don't encourage anyone to be vigilant about bringing a claim, if you will, when they could have had actual knowledge is required. Here, we know that Mr. Chisum's lawyer knew what was going on. We know that the LLC's lawyers knew what was going on. That knowledge is imputed to either the LLC, Mr. Chisum, or both. And no claim was brought within 3 years, if there is an actual knowledge requirement, of the date that the LLCs and Mr. Chisum acquired actual knowledge of the basis for his claims, declaratory or otherwise. The performance or non-performance of the defendant's duties as managers arise from the contract. I have attempted to find, but I cannot find, a case in which this court or any other court has held that anything other than a 3-year statute of limitations would apply to any claims arising out of a contract for constructive fraud. Meaning the claims that have applied, for instance, a 10-year statute of limitations have been when there has been no actual contract between the parties that controlled their conduct, that controlled their relationship.
Mr. Shivak, let me ask you a question. Again, sort of a threshold question. I just want to make sure I understand your argument. I understand you're arguing that actual notice to the plaintiff is not necessary for the statute of limitations to begin to run. But what about constructive notice? Is there a constructive notice requirement?
Is there an instruction? Is that
I'm
what
sorry,
you said?
a constructive notice requirement. Does the plaintiff have to be reasonably on notice, even if not actual?
If we follow what this court said in the Pierce case, when we follow what this court said in the Pemby case, when we follow what this court has said as to when an action accrues, no constructive notice would not even be required, because the law, Justice Davis, rewards the vigilant. This is not a situation in which the plaintiff contends that he was deprived of an opportunity to know the truth during this entire period of time. In fact, he acknowledges that he could have. He acknowledges that he never even made contact with the defendant. His attempts were limited to his own attorney to find out the truth. So this is a situation where, again, when we get to the concept of constructive notice, actual notice, both Mr. Chisum individually and the LLCs had actual notice of the conduct that formed the basis of the claims for breach of fiduciary duty and constructive fraud.
Can I just ask on that point then, what is the impact on the question of notice, the fact that the Schedule 1 to the operating agreement was never actually amended?
The effect is none. Number one, the act had taken place. The act of excluding him had taken place. K1s, you're talking about the schedule in the actual operating agreement. The last K1 that was received by the plaintiff for the entities are at issue were for 2012, and he filed his tax return in April of 2013. He got no further documentation, information whatsoever from and after that date. And he acknowledges that when he did not get a K1 for 2012, he thought that odd. And of course, he never got a K-1 for any period of time after that. The fact that the schedule wasn't changed is of no consequence. The act that formed the basis of the claim of injury had occurred by that particular point in time.
But by the terms of the operating agreement, isn't the schedule what legally defines ownership in the partnership? And so then I would ask what your response is to the plaintiff's argument that this is analogous to someone standing in the street and pointing to my car and saying, no, that car belongs to me. Like, what matters is whose name is on the title, right?
And as we argue back, it's more than just someone claiming that's the car. We got in the car, we drove it away, we put new paint on it, we bought new tires, we maintained it, we filled it with gas. And only years later, when the plaintiff thought the car was valuable, did he show back up and complain about the fact that we had been riding around in his car. That's the analogy that's pertinent here relative to what did the plaintiff know and when did he know it. So given that the relationship arose from contract, given that the injury occurred more than 3 years prior to the filing of any action, then any claims, both individually and derivatively, are barred by the statute of limitations. With respect to our remaining arguments on the failure to direct a verdict on the claims of fiduciary duty, constructive fraud, given no evidence regarding actual damage, given that no one ever testified that any of the transactions that formed the basis of those claims were improper, given that no actual damages were awarded to Judges Road, given that there was never any claim that could be made against Rocco Campagna for constructive fraud, given that the jury found no breach of fiduciary duty. Again, we've already talked about the failure to deliver the open and honest instruction being erroneous. We've talked about in our brief, you can't have punitive damages without actual damages. No actual damages were shown with Parkway. None were awarded with Judges Road. The judicial dissolution issues, we rely upon our brief as to the impropriety of that. I'll be happy to answer any other questions that the court may have at this point, but otherwise we'd reserve our remaining time for rebuttal.
Madam Chief Justice, and may it please the court, my name is Mark Sigmund and I represent Dennis Chisum. Your Honors, after hundreds of pages of rulings and an 11-day trial, the business court got most things right in this case. It got a few things wrong, however, including about the statute of limitations, where it made its job harder than it needed to be, and about punitive damages. This court should affirm most of what happened below in reverse in just a few limited respects. Now, on limitations, Mr. Chisum has several independent arguments here, any one of which is sufficient to affirm as to the two companies and then reverse as to the one company that my client is appealing. So what are those arguments? First, there is no limitations that applies to a declaratory judgment claim. The general statutes don't list one, and there are plenty of cases holding exactly that.
But my understanding, Mr. Sigmund, is that there's no case that holds explicitly that there is not a statute of limitations. Is that right?
That's correct, and there's also no case that holds explicitly that there is.
Right, but we do have cases, don't we, in which from this court, in which statutes of limitations have been applied to declaratory judgment claims.
Yes, there have, and there have been others,
and we got some others where they're not mentioned. Is that
correct? And importantly, the other cases where laches applies, because undisputedly laches applies to declaratory judgment claims, and that provides the time structure here. No one's going to be sitting on their hands with declaratory judgment claims here. Laches will always apply. Now, it doesn't apply in this case because the court struck it, because Mr. Campagna testified falsely at trial. But in every other case, that's the boundary. So
are we gonna, in the event that we were to agree with you with respect to your contention that there is no statute of limitations that applies to a declaratory judgment action, are we going to have to overrule these earlier cases that do apply statutes of limitation to declaratory judgment claims?
Your Honor, I think it would be more in the nature of clarification. I don't think that the court would need to explicitly overrule anything. I think the court would need to say what the business court here said, which is there's cases on both sides. It's not entirely clear. It's our job to make it clear. Here's what the rule is. Second, even if there is a limitations period here, the period here should be 10 years, the period for constructive fraud, because here, the declaratory judgment action directly impacted the ability for the one company to make a constructive fraud claim. And so if you are going to play this guessing game, and I don't think the court should be in the guessing game of what statute applies and trying to figure it out, but if you're going to play the guessing game, it should be that the limitations of period that applies is that which has any practical effect on this case. And here, there was a practical effect on the one company related to constructive fraud, and therefore the period here should be 10 years.
Is there a practical effect from a breach of the operating agreement interfering with your client's membership status?
If I understand the question, Your Honor, the practical effect of the supposed breach is that my client, according to the trial court, there's a 3-year limitations period, but that prohibits and CCH from making its derivative claims for constructive fraud, which goes back 10 years, which is why here we allege derivative claims on behalf of the one company. Those have a 10-year limitations period, undisputedly, but the trial court never instructed the jury on those claims. Now, why not? Because once the court had decided that 3 years applied to the declaratory claim and then directed verdict on that, it made no sense to even send those claims to the jury. And so my argument here is that.
Well, and I thought maybe I misunderstood, and please tell me if I have. That's part of the reason for having these arguments, is to make sure we all understand what the situation is. My understanding of the non-submission of the individual claims was that all of the damage claims were derivative in nature rather than individual. Is that wrong?
So the court took the claims and said certain claims, the injury is to the company, and those are derivative. Certain claims are individual, and those are to the individual. But then on the motion to dismiss, very early on in the case, held that the individual claims could not be stated to the extent they relied on any duty, like fiduciary duty. And that's the Barger argument that's at the end of the brief. But the short answer to Your Honor, at trial, most of the important claims were derivative, but there were some individual claims. For example, failure to pay pro rata dividends, things like that.
And that was submitted, and your client got an individual recovery on that basis, didn't he?
Yes, Your Honor. Yes.
And I don't even understand that to be in dispute at this point, is it?
That's not, no. So again, 2 arguments. 1, there is no limitations. 2, if there is, 10 years. So let's move on to if there is, what if it's 3 years? First off, even if limitations applies and it's 3 years, Mr. Chisum should still prevail because the Schedule 1 was never amended. Contracts matter. Everyone testified that the Schedule 1 was the definitive statement of what someone's interest was. It's like a title to a car. It's a definitive statement. And until that document is amended, then it controls. And that's a simple rule, and it's the right rule. And again, if this court adopts that rule, it can affirm as to the 2 companies, reverse as to the one that I'm appealing, and then move on. So that's a third argument that is entirely correct basis on which to rule. Now, let's say, for example, that the Schedule 1 does not control as a matter of law. And so now we're in the world of what the trial court thought and what the case that was tried. I want to be crystal clear here what the defendant's argument really is, because their argument is a single secret breach. A single secret breach will start the clock on limitations, even if the other side has absolutely no idea about that. Here, for example, they claim that the Campagnas in 2009, let's say, could have had a secret meeting, issued a ruling between themselves saying Dennis Chisum is out, told nobody about that, and that would start the clock. Now, I frankly don't blame the Campagnas for making that argument. And I don't blame them for making it because they have to make that argument. They have to make that because if they concede anything else, if they concede that something other than a secret breach is enough, then you get into the world of what the trial court held, that there's a fact issue. Where in that chain of events is there an actual notice or a constructive notice? Where in that chain of events? Because here there was conflicting testimony. The Schedule 1 was never amended. The K1s for the two companies were not amended until less than 2 years before we filed suit. Mr. Shipman had that wrong. It's less than 2 years. So if you actually get into the weeds of the facts, there's plenty of facts here to show that Mr. Chisum should not reasonably have known that they were kicking him out less than 3 years before. And so the Campagnas have to avoid that factual morass. And so, but the only way they can do that is by making this argument that, frankly, is just absurd, which is that a single secret breach is enough to trigger limitations. And note, and I want to be clear about this too, there was not a single case of this court, of the Court of Appeals, that they cite, that I cite, that sanctions that result. Even in all the cases that they cite, there was actual notice of the breach or constructive notice. You will not find a single case that says, you know, John and Mike had a contract, John breaches, but Mike had no earthly idea, and yet the clock started running. There is no case that holds that. To the contrary, the NC Farm Bureau versus Hull case, adopting the dissent of Judge Tyson, that holds that the notice rule applies. Similarly, this court's decision in Christenberry in 2017. The Campagnas argue it's a canard all about how these are about what's it called?
Anticipatory breach.
Anticipatory breach. That is simply not true. Number one, there is no limitations period for anticipatory breach, because anticipatory breach, you don't have to sue. You can sue, you don't have to. And that's exactly what those courts hold. They hold that anticipatory breach does not even trigger anything. So both of those courts' discussions in those cases about what does trigger it, that was after they held that there is no anticipatory repudiation, and they are discussing then what, in those cases, what were the facts that actually triggered the limitations in those cases. And so the anticipatory repudiation argument is simply as a canard. This court held notice applied in the Parsons case in 1966. The Court of Appeals has held it. Ludlam, Henlejohn, Abram, Jones, Footlocker. The federal courts have held that. I cited the Biltmore case. The business court has held that. I cited the Zagaroli case. Everyone is applying a notice rule here. And by the way, I want to be clear that, and I think our brief was pretty clear about this, the notice rule has always been the rule. The Campagnas have gone out of their way in their briefs to pretend like Mr. Chisum is arguing that there's some great sea change recently in the Hengelon case or in the Hull case. That is not our argument. We are not arguing that there's some big change in the law here. We are the ones that are saying that the rule, we are the ones asking you to apply the rule as it's always been applied. Finally, Your Honor, on that issue, the trial court, I think, realized here as well, which is what was the nature of the breach? The nature of the supposed breach is kicking Mr. Chisum out of the companies. How does one do that? You can't do that secretly. You kick someone out by giving them notice. And so what the court ultimately acknowledged here in its 79-page post-trial order, where it addressed this issue at, I think, about 40 pages, it held that in this case, the notice was the breach. And so the Campagnas could not have breached the operating agreement until it actually provided notice. But again, I want to rely also on the Schedule 1s and the fact that they were never amended. So again, I don't even think that this court needs to get into the factual morass that the trial court did. I think there's about 4 different off-ramps on that highway before you even get here. And I think that they're all correct. I don't think limitations applies. If it is, it's 10 years. If it's 3 years, then the Schedule 1 was never amended. And only if you miss all 3 of those off-ramps, do you then get to what the trial court did, in which case I think the court should affirm because the jury ruled in our favor, but it should reverse as to the one entity that it directed a verdict on, CCH. Now, why? Because again, the Schedule 1s were never amended. The jury could have found that that was enough, that my client did not have notice. There was never a phone call or email by the Campagnas telling him he was out. My client used the mini storage facility until 2016. And that's actually when he had real notice in this case, was when he and his son drove up to this facility owned by one of the companies, and he realized that he was no longer an owner. All of that is more than a scintilla of evidence that a jury could have used to find in favor of my client regarding CCH. Finally, just very, very...
The trial, excuse me, Mr. Sigmund, I just want to make sure I understand your argument with respect to one subject. If I'm reading the trial court's orders correctly, it may not be. But if I am, it seems to me that the trial court in essence said that your client received the K-1 outside the limitations period that showed that he had no interest in CCH, and that therefore that gave him notice, and that triggered the running, that at that point the statute accrued as to CCH. If that's not the right understanding of his order, please correct me. If it is, why is that wrong?
Your Honor, I'm not sure that the trial court was explicit about what exact facts it thought necessitated a directed verdict for CCH, the company, but I agree that that was the main fact that it relied on. So I think that was primarily it. Why is that not enough? It's not enough because, again, the Schedule 1s were never amended. And so even if they don't control as a matter of law, which I think they do, there's still evidence that a jury could look at. It's more than a scintilla. I mean, if I owned an LLC and I had a Schedule 1, and by the way, Mr. Chisum asked the lawyer, McDonald, he said, am I still a member? And the lawyer told him, you're a member to the extent shown on the Schedule 1. He said that was his position, quote, all along. And so I think a reasonable juror could look at this, the lack of amendment of Schedule 1 itself, and that would be enough. And so you would have conflicting evidence. You have the K-1 over here, but you have the lack of amendment to Schedule 1 over here. And then there was other evidence too, the use of the unit at a storage facility, and other things like that. And in fact, the only real difference between the three LLCs here was the K-1, right? For two of the LLCs, the K-1 was sent later, and one of them it was sent earlier. That's the only real difference. But the accountant, Mr. Hardison, actually stated that a K-1 is not the best way to let someone know that they're being kicked out of a company. That if you're going to do it, you need to follow the law, follow the rule, follow the operating agreement. That's the way you kick someone out. And undisputedly, they did not follow the operating agreement here. It had a procedure laid out for what exactly you need to do to kick somebody out. They just never followed it. And finally, there also is equitable estoppel. I think that, even if the court were to reject all of those arguments, I think that the trial court still should have ruled or still should have instructed on equitable estoppel. In fact, equitable estoppel is the one argument here that the trial court never addressed. It was a very thorough trial court in its 79-page post-trial order, but for some reason, it never addressed that argument. I think at the very least, we would go back on that. I don't think we should. I don't think there's any need for that. I don't want to retry this case, trust me. And again, there's 4 different ways to avoid that on the limitations issue. Let me move on to my other main cross-appeal argument, which is about punitive damages. Your Honor, there is no law clear in this court about what happens in this situation. This court has to make law one way or another. That's what this court does and what it does well. My main argument on punitive damages is simple. It makes no sense. You don't give punitive damages back to the guy that they're awarded against. It makes no sense. I've cited 4 cases. We did a lot of research, and the only 4 cases we found were the ones that we cited. I have not found any case other than that, no case to the contrary. So every court that squarely addressed this issue of when you award punitive damages against an individual on a derivative claim, do you then just turn it around and put it right back in his other pocket? No court has done that. No court has sanctioned that, and it just makes no sense. It violates the purpose of the punitive damages statute. It violates the pattern instruction, which is always about punishing. It violates the analogous policy of wrongful death, which is also a quote unquote derivative action. And by the way, that's
Mr. Sigmund, wasn't the jury aware that that would be the result of its verdict? I mean, couldn't it have rendered a different verdict on punitives if it found your argument persuasive?
Your Honor, I don't think that there's evidence that the jury was aware that that was the result. If you look at the actual instruction given to the jury, the most reasonable reading of that is that they thought that they were punishing the Campagnas by making them pay X dollars. And there was a line, and they wrote in a number on the line. And they thought that that was the number that they would have to pay. I think that's the most reasonable ruling. But to be fair, to be very clear, the jury was not explicitly instructed either way. So we're not 100% certain what the jury found, although we raised this issue with the trial court even before the principal verdict came back. And so the trial court was aware of this. The Campagnas could have sought a jury instruction to clarify it if they had wanted. But the short answer to your question is it's not entirely clear, but I think the much stronger reading of the record is that the jury thought that the campaigners were going to have to pay the amount of dollars they wrote down on the blank.
Am I remembering correctly? I'm sorry. Go ahead, Justice Servant. Well, I was just going to follow up on your answer, Mr. Sigmund. Am I correctly remembering that you did not request a jury instruction on that issue?
Your Honor, that's correct. We did not. Neither did the campaigners, and we raised the issue with the trial court before the main verdict came back. Before we even started trying the case on punitive damages, we told the court. We said we think there's authority out there. And by the way, we don't think you need a jury instruction on this. But if you look at the cases we cite, the rule that they applied is simply you get an award, then you just bar the bad actor from sharing in it, just like you do with wrongful death. And so we don't think it's a matter of jury instructions. We think it's simply a matter of when the award comes back, you just bar the bad actor from sharing. And honestly, that's a really easy result in this case, because the trial court immediately dissolved these LLCs at the end of trial. Okay, and so it's not like the money goes back to the LLC and then years go by. The fact that the money went from their left pocket to their right pocket under the current situation, that's an immediate result. The
jury, Mr. Sigmund, the jury was instructed, wasn't it, that the punitives award would go to the LLC?
Yes, yes, that's correct. It was, and
it was. I mean, the relative ownership percentages in the LLC were also known to the jury through the evidence received at trial, right?
Yes, they would have known the final percentages. Yes, yep. But my point, though, is that if you look at it, I think the most reasonable reading is the jury thought that the money was going to go out of the pockets of the campaigners. Now, the jury did not know that the LLCs were going to be immediately dissolved, so they might have thought, well, the money goes out of the pocket, out of the campaigners' pocket to the LLCs, and then, maybe years will go by and they'll be forced to be reinvested in the LLCs, and the LLCs will then use that money to do whatever they want. But I think that what the jury was unlikely to have believed was that immediately upon they're rendering the verdict, that 80% of that money would go directly into their other pocket.
Well, I do hear that you're candidly acknowledging speculation as to that, but in terms of what you're saying about the punitive damages actually going back to the defendants individually, isn't that somewhat of a misnomer when you consider that a derivative action is to benefit the LLCs as the plaintiff brought the action? So as a result, since there was that business structure and the plaintiff was bringing the action on behalf of the LLCs, that it's not quite correct to say that the defendants were benefiting directly, because the plaintiff was actually protecting the honor of the LLCs and bringing the action, which led to the punitive damages.
Yes, Your Honor. The way I always think of it is, when it comes to compensatory damages in a derivative action, the rule is clear. Always goes back to the LLC, even if the person that's paying it is a 50% owner of the LLC and is the bad actor. I think punitive damages is just different. It's different because of the whole purpose of punitive damage is to punish, and it's also different in this situation because the LLCs were immediately dissolved. And so as soon as this verdict was rendered, these LLCs are gone. And so it's not a situation where the money can go back and then be used for some other purpose. And so I think that the difference is, the relevant difference is the difference between punitive damages and compensatory damages. And, Your Honor, the four cases I cite, they all dealt with this issue. And, they cited a Harvard Law Review note that talks about all these issues. And they talk about the nature of this. A derivative action is an action on behalf of the company. Everyone knows that. And therefore, generally, the recovery goes back to the LLC. Everyone knows that. What these cases acknowledge, though, is that it just makes no sense, especially in a punitive sense, to adhere to that rule so hard and so fast that you end up with the absurd result of giving money right back to a bad actor. And that's all we're asking. If the court briefly, has the time to look at those four cases and the discussion of the issue, it just makes sense. And I'll rely on that. If the court has no further questions on anything else, I will reserve the rest of my time for rebuttal, but I'm happy to answer any questions right now. Thank you.
Mr. Shipman?
No case cited by the plaintiff overrules the established precedent from this. Lack of knowledge concerning a claim does not postpone or suspend the running of the statute of limitations. That's Pierce. That a cause of action accrues at a time an injury occurs, even when the injured party is unaware that the injury occurs. That's Pemby. That statutes of limitation are inflexible, unyielding, operate without regard to the merits of the underlying claim. It is not up to this court to justify the limitations period contained in 1-52. That's up to the legislature to provide.
Mr. Shipman, to go to an argument that Mr. Sigmund made, can you cite any case that on its facts holds a breach of contract claim brought by a party to have been time barred even though the plaintiff did not know that the claim had accrued?
Justice Urban, I can say candidly, I can't say that I can, but what I can say is that this court has held that in finding when an injury occurred, that lack of knowledge about when that injury occurred and then bringing a claim more than 3 years thereafter barred. But no, sir, I can't quote to you an exact case that says that lack of knowledge does or doesn't bar. I have merely focused on the fact that under Pierce, under Pemby, under Penley, that the fact that they don't know when the injury occurs is of no consequence to when the statute of limitations occur or begins to run. Because again, if there was a tolling provision, if there was a discovery period for a breach of contract claim, the legislature would have already provided it as they have on other claims, and they didn't provide one here. All of the actions undertaken by the defendants after the breach being, as they admit, kicking me out of the companies, are nothing more, Justice Newby, as you said in Christenberry, than the continual ill effects from an original violation. All the claims.
Can you respond to Mr. Sigmund's argument that here the notice to Mr. Chisum was the breach?
Yes, I respond to that. That under the law, that's not true because the time period had already commenced to run. Now, again, I get back to the point, Justice Davis, that notice in 2010 that you're being kicked out can be a way that a statute of limitations can start to run, but it is not the only way. But the fact that he says 6 years later, when I got notice of the transactions that form the basis of my constructive fraud and breach of fiduciary duty claim, that's when they commence to run, I find no case that supports that. I find cases that, in fact, given that the relationship arose out of contract, provide for the contrary. That the statute of limitations is 3 years from the date that any injury first arose, especially given that the allegation is that the breaches were kicking him out, assuming control of the companies, selling the company's property, all of which occurred more than 3 years prior to the time that the statute of these claims were filed. Justice Urban, with respect to the proposed jury instructions, if you will look at the record on appeal on pages 1227, 1230, 1237, 1240, 1247, 1250, with respect to our proposed jury instructions with respect to fair, open, and honest, and again, the fact of what the impact of that would be if a jury determined fair, open, and honest.
Thank you.
With respect to the notion of equitable estoppel, again, we need to focus on the fact that the derivative claims were by the companies. The plaintiff individually was owed no duty. And so the idea and notion that what did Chisum know, the plaintiff know, and when did he know it, is not the issue. The issue with respect to the derivative claim is what did the LLCs know and when did they know it? And of course, the LLC's lawyer participated, condoned, provided advice, and consented to all of these transactions. And I'd like to reserve the remainder of my time for my final rebuttal.
Mr. Sigmund.
Yes, Your Honor. Thank you. I'm happy to answer any questions. I'm not sure how much rebuttal I have, frankly. I mean, I appreciate Mr. Shipman's admission, and I think it's correct that there is no case out there that on its facts would allow the result here. And I don't think that I've not briefed any law in any other states, but I'm not aware of any other state's law either that would allow a single secret breach. Again, I don't think you need to get there, but I appreciate that. There's some other issues that we haven't addressed yet. I don't want to go out on a low note, but I'm happy to address them if the court is interested. The Campagnas have argued that the judgment, one of the judgments, was wrong because there was only nominal damages. The trial court clearly held that argument was waived, and it was waived. However, even if that argument was not waived, I think it's clear under the law that nominal damages are allowed. They're allowed by the pattern jury instruction for those claims, and I don't think this court wants to be, I don't think it should take up the invitation to overrule the North Carolina pattern and jury instructions in this appeal. That's also true for fraud, negligent misrepresentation, other claims as well. Nominal damages are allowed for all of those. That argument was also rejected by the Court of Appeals in the Bogovich case, and I think that the Campagna's attempt to distinguish that fails. The verdict against Rocco Campagna was not inconsistent. The fact is, and the Campagnas never cite the Orr case. The Orr case makes crystal clear that fiduciary duty and constructive fraud are different. They're different. They're not only are they different, but because they're different, they have a different statute of limitations. And therefore, the verdict against Mr. Rocco Campagna is not inconsistent. They also argued that the verdict against that the verdict for Parkway was ambiguous because it awarded the same amount of damages against both of the Campagnas, against Richard Campagna and Rocco Campagna. I want to point something out here, which is that, as the trial court noted in its post-trial order, there was no joint and several liability here, and the jury found no conspiracy. And so what does that mean? All that means is that you now have two different defendants, totally independent, and the same jury award was levied against each of them. That does not render the verdict ambiguous. Under the Campagna's argument, if you have two defendants in any case, and the jury happens to award the same amount of damages against the two defendants, that's ambiguous, and you have to send it back. That's not the law. I don't think this court wants to be blowing up every jury verdict out there just because there's two defendants with the same award against them. Finally, on dissolution, I don't think this is really a big issue at all. I think clear that the dissolution of the trial court was proper, and I've argued all that. Frankly, I'm not even that worried about it because if the court were to remand, I'm pretty sure that the trial court's going to redissolve the case immediately anyways, dissolve the LLCs immediately anyways, because as the trial court issued, these parties are at each other's necks. These companies need to be dissolved, and it did the exact right thing there. Your Honors, I have no further points to make. If the court has any questions, I'd be happy to answer them. Again, on the main issue, I just want to be very clear. There is no statute of limitations. If there is, it's 10 years. If there is, and it's 3 years, the Schedule 1s were never amended. If after all of that, you get into the realm of the trial court, then the court should still affirm as to the two LLCs. It should still reverse as to the one, CCH, because there is plenty of evidence here. So under any of those ways, this court should rule in favor of my clients. If there are no further questions, thank you.
Mr. Shipman.
Simply holding to the unyielding bar of the 3-year statute of limitations ends this case, as indeed it should, given that statutes of limitations operate inexorably without regard to the merit of the underlying claim, thereby, quote, preventing surprises through the revival of claims that have been allowed to slumber. Justice Newby, your words from Christenberry. As this court has cautioned, quote, he must keep awake and be alert, exercising the care and watchfulness of an ordinarily prudent man in protecting his rights and saving his interest. That didn't happen here. Even the trial court acknowledged that with respect to the declaratory judgment claim, there was a statute of limitations under 1-52(1), but imposed this requirement that the plaintiff had to actually have notice. Let's take that to the derivative claim that was filed more than 4 years from the date of the actions that form the basis of its derivative claims, with the LLCs having known through its lawyer about everything that had occurred in that interim period of time. Regardless of how the 3-year statute of limitations, therefore, is applied, it does not include a discovery rule. That is up to the legislature to impose that. The idea and notion that in response to counsel for the plaintiff's arguments that the verdict against the defendants pertaining to Parkway, when he said in his oral arguments to the jury, just fill in the same amount and the court will make sure that there's no double recovery. Well, the jury did exactly what it is that counsel for the plaintiff asked them to do. The $128,000. The plaintiff couldn't provide any basis whatsoever as to where that came from because, of course, there was never any evidence of any actual losses suffered by Parkway. There was never any evidence of any loss of profits suffered by Parkway. And so that claim for constructive fraud for breach of fiduciary duty should never have gone to the jury. But when the jury did the very thing that counsel for the plaintiff invited it to do by filling in the same amount, then indeed, again, that was when the ambiguity arose. Mr. Chisum has formed the basis of his claims for breach of the operating agreements premised upon the assumption of control. That is in the transcript at pages 749 through 752. The primary breach about which he complains is the transfer of property. Mr. Sigmund's own argument makes that clear. All of that occurred more than 3 years prior to the time that any action was filed, whether it was in August and September of 2012 or whether it was in January of 2013. In order to ensure that there are not stale claims, in order to ensure that this court promotes the policy that one cannot sleep on their rights, that one must be vigilant. In all due respect, all of the claims are barred by the statute of limitations because all of the acts that form the basis of those claims occurred more than 3 years from the date that any injury about which they claim occurred. I thank the court and be happy to answer any other questions that you might have.
Thank you to both counsel. Madam Clerk, would you recess us for 15 minutes?
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court. Thanks, Gary and Mark. Y'all have a good rest of the day, okay?